So I'm about to read and give some commentary on the Clerky Handbook. You can find this handbook at handbook.clerky.com. That's where the most up-to-date version will be, but I wanted to make it a little bit more accessible because it's such a great guide. So I wanted to make this sort of audio commentary version of it, but all the content here is owned by Clerky. Go to handbook.clerky.com to read the original version and the most up-to-date version. And thanks to Clerky for providing this great guide. It really resonates with my experience with startups. So my background is I'm a startup founder. I did the Techstars program. I've done probably 2 real startups by now, is what I would say. The legal concepts for those startups were always pretty confusing. So I figured, since there is not an audio version of the Clerky Legal Concepts for Founders handbook, I would read it, and maybe you could listen to this as audio content or something like that. Maybe we'll learn something about startup legal stuff. I've learned a lot of this through practice. I'll maybe between sections, I might comment on something. I haven't read it yet, so it's completely new to me. Also, since I'm reading legal advice, maybe I should say quickly, I am not a lawyer. Introduction to Legal Concepts for Founders. Here at Clerky, we build software to make legal paperwork easier for startups and their attorneys. We're the most popular way for startups to get formation paperwork done and have products covering everything else typical seed startups need. Chris and I started Clerky in 2011. As startup attorneys, we noticed that many startups had costly errors with their legal paperwork, usually the result of using low-quality services or DIY approaches. With our engineering backgrounds, we knew that this problem could be solved through software built with the right legal expertise. Thus, Clerky was born. As startup attorneys, we did a lot of legal paperwork for founders. But because we did the work ourselves, and because every email came with a steep price tag attached to it, we weren't exposed to the full range of questions we get at Clerky. As a result of having largely unfiltered feedback from founders and informed by our legal expertise, Chris and I have developed unique insight into what causes the most confusion for founders. This handbook is designed to help founders avoid common areas of confusion by providing a solid foundation of legal knowledge. This handbook is organized into 4 sections. The first, Core Concepts, is meant to provide you with a general background on how corporations work. It's a good starting point, even if you already have some familiarity with the subject matter. The remaining sections, Formation, Fundraising, and Hiring, focus on the 3 major areas of legal activity for startups. We will be continually updating articles to ensure the handbook is always up to date and are planning to add many new articles as well. We've had a fun time putting this handbook together with our amazing editorial board. We hope it proves to be a useful resource. If you have any feedback, please don't hesitate to reach out. We'd love to hear from you. And again, if you're interested in reading more about Clerky or maybe using their services, I'll put the link below to this handbook. And it's also, I guess it's at clerky.com. So pretty easy to find. So the next section is just their editorial board. I'm sure they're a bunch of smart people. Audience. So audience for this handbook. The word startup means different things to different people. For the purposes of this handbook, we use the term to refer to companies that plan to raise or have raised money from an accelerator or venture capital firm, commonly referred to as VCs. Some companies may not fit within this definition, but still want to model themselves from a legal perspective after startups in order to leverage the legal ecosystem around startups. This handbook should be useful to such companies as well. This handbook is written for startup founders with a focus on topics relevant to early-stage startups. The term early-stage startup also means different things to different people. For some, it might mean a company that has raised Series A or even Series B. For the purposes of this handbook, we use the term to refer to startups that have not yet raised Series A financing. This means startups anywhere from pre-formation to having raised a seed financing. Finally, the content in this handbook is only relevant for Delaware C corporations. Corporations. In normal speech, a person is generally synonymous with a human. In law, however, a human is only one type of person. The law defines other types of legal people, also referred to as legal persons, that humans, also known as natural people or natural persons, can create. A corporation is one type of legal person that humans can create. By allowing corporations to be considered legal people, the law makes it possible for them to hold legal rights and obligations separate from their owners. Actually, didn't know that. I didn't know that a corporation is a legal person. So I guess that's a little bit of law terminology I just wasn't familiar with. I never would have expected that. Each state has its own rules about how to form a corporation. In Delaware, people form corporations by filing a document known as a Certificate of Incorporation with the Delaware Secretary of State. Once the filing has been accepted by the Delaware Secretary of State, the corporation comes into existence as a legal person. Terminology. What is the difference between a corporation and a company? A corporation is a type of company. Company is a generic term used to refer to a business and does not imply any specific type of legal entity. Okay? Any startup attorney, as well as clerky, can help you file a certificate of incorporation with the Delaware Secretary of State. Related topic. A Delaware corporation can elect to be a public benefit corporation in its certificate of incorporation. Registered agents. The certificate of incorporation filed with the Delaware Secretary of State must name a registered agent for the corporation. The registered agent of a Delaware corporation must be physically located in Delaware and is responsible for receiving legal and government communications for the corporation. There are many companies in Delaware that provide registered agent services for a fee. Most startups use one of these registered agent companies. So I think I've used two companies in the past as my registered agent. One was provided by Stripe via the Stripe Atlas program, and it was maybe like Rocket Lawyer or something like that was the name of the registered agent. And then I also used Harvard Business something, which was, I don't even know if it's associated with Harvard, to be clear, because Harvard is, I think, a place as well. But they acted as my registered agent for my first startup. And yeah, it was an easy online process to get this registered agent in Delaware. Although registered agents provide your corporation with an address in Delaware, they typically only allow the address to be used for communications from the Delaware Secretary of State and court-related notices and return other mail to the sender. Consequently, startups should have a separate business address and use it exclusively whenever asked for an address, unless asked specifically for the registered agent's address. So don't use your registered agent's address for things other than a kind of Delaware business or a court order, I suppose. Registered agents typically also serve as a filing agent for their customers. Filing agents make filings with government agencies such as the Delaware Secretary of State. Registered agents charge a fee for their filing agent services. Most startup attorneys, as well as clerky, automatically select a reliable registered agent for you at a steeply negotiated discount. Okay. So sometimes your legal firm can get you a discount with a registered agent service company. Incorporators. When a certificate of incorporation is filed to incorporate a new corporation, the Delaware Secretary of State requires that it be signed by an incorporator. With most startups, the incorporator elects an initial board of directors after the certificate of incorporation has been filed. The incorporator can elect him or herself to the initial board of directors. The incorporator typically executes a document called an action of incorporator, also called an initial action by the sole incorporator, in which the incorporator adopts bylaws for the corporation, sets the size of the board of directors, and elects the initial board of directors. The role of the incorporator ends there. So you have some person who is the, I guess, person who incorporates the business, and they set up this simple initial structure, and that's all they do. And then they're not involved unless they put themselves on the board of directors. It usually doesn't matter who the incorporator is, primarily because the corporation has no assets at the time of incorporation. If the incorporator elects an initial board of directors that his or her co-founders disagree with, they can simply incorporate a new corporation on their own. For this reason, the incorporator for a startup is typically the founder who is most willing to handle the paperwork. Some law firms have a paralegal or attorney serve as the incorporator. So the incorporator isn't that big of a deal, basically. As long as they do it right, and if they do it wrong, you can always do it again. The incorporator isn't, you don't have to worry too much about who's signing that initial paperwork. Board of Directors. The Board of Directors, often referred to as the board, is the governing body of a Delaware corporation. The Board of Directors has a specific number of seats. There is no minimum number of seats. Solo founders are often the only director at company formation. Most startups are set up so that the size of the board can be easily adjusted at any time. The number of directors can never exceed the size of the board. The board makes decisions either in board meetings or in writing, referred to as written consent. By default, the board can make decisions with a majority vote of the directors present in the meeting. Or, if the board is making a decision by written consent, unanimous consent of all directors is required. In practice, most board decisions for an early stage startup are made by written consent due to simplicity. So just get everybody to sign off on it. Then you don't have to worry about all that voting. If a decision is made in a meeting, a quorum is also required. A quorum is the minimum number of directors that must be present at the meeting. This is usually a majority of the total number of directors. The board cannot make any decisions in a meeting if a quorum is not met. A quorum is irrelevant for board decisions made by written consent, since written consents require the unanimous approval of all directors on the board. Now, this is kind of interesting to me because I actually thought that when you put your company bylaws together, this was part of the company bylaws. And I'm not sure if this is what Clerky puts by default in your company bylaws, or this might actually be part of Delaware law where the board of directors have these privileges. Written consent always must be unanimous. As mentioned earlier, the initial board of directors is elected by the incorporator. Once a corporation issues stock, the stockholders control who is on the board of directors. For most startups, the board of directors consists solely of founders until the Series A financing. Venture capitalists typically join the board of directors in connection with their Series A financing. Yep. So you get a bunch of money. They put in like $1 million, which is more money than your startup's ever seen, and they get a board of directors seat, and they can do stuff. And when you get to Series B, Series C, maybe you have a lot of other people on your board. And finally, you have so many people on your board that they can actually remove the CEO or something like that. Although at that point, it might be in the best interest of the company. Who knows? Yep, makes sense. Terminology. There can be some confusion due to the fact that job titles contain the word director. For example, director of engineering. Despite appearances, giving someone such a job title does not put them on the board of directors. Yeah, the board of directors is a special thing. Officers. The officers of a Delaware corporation are appointed and removed by the board of directors. Officers are in charge of managing the company day to day. Most startups start off with at least a CEO and a president, a CFO and treasurer, and a secretary. In an early stage startup, the CEO and president are often the same person in order to avoid any confusion as to leadership and because the roles are so similar. The CFO and treasurer are usually the same person as well. If you have a little bit of tension between founders at the beginning, sometimes one of them becomes a president and one of them becomes CEO because you're not sure who the CEO should be or something like that. And it's a way of splitting the difference. It's kind of useless to do something like that. You're not really going to use your powers given to you by those titles to do anything. Usually it won't really matter. You're both so essential, most likely. Yeah. And the other thing I'll say is investors usually like to see strong leadership. So if you have kind of divided leadership, it's going to be confusing for them. If they want to talk to the person in charge, you don't want to have two people in charge. That's from my experience. There is no limit to the number of offices one person can hold, nor is there any requirement for offices to be held by different people. Solo founders typically hold all the offices in their startup. For example, under Delaware law, corporations are not required to define any particular officer titles. However, most startups will need to register to do business in their home state, which might require the existence of typical officer positions. After you incorporate, you'd have to do other registrations for any state you do business in. For most early stage startups, the primary decision is who will be the CEO and president. Other officer titles tend not to have much meaning since everyone is doing a little bit of everything and the roles are constantly changing. Offices can usually be added through an amendment to the bylaws or by the board of directors. Typically, an office must be formally created for a corporation before anyone can hold it. For example, if Chief Technology Officer is not an officer position, you can have an employee with the Chief Technology Officer as their job title, but they would not be an officer of the corporation. Yeah, so it's got to be in the bylaws if you want to add this official Delaware officer kind of thing. Stock. Ownership of Delaware corporations is represented by shares of stock. Stockholders are people who own shares and thus part of the corporation. Even though they are the owners of the corporation, stockholders don't control the corporation directly, although stockholder approval is required for certain decisions. Instead, they control who is on the board of directors, which in turn controls the corporation through the corporation's officers. Startups usually issue either common or preferred stock. Preferred stock has additional rights and privileges that common stock does not have with respect to liquidation and dividend preferences at a minimum. Startups typically issue common stock to founders, employees, and consultants, and issue preferred stock only to investors. Yep, so basically, let's say you're a startup and you're taking some investors' money. That investor is going to say, look, if you gave me common stock, this company, if it were to be liquidated, if it were to be sold, I might not get my investment back. So I want to get, how did they write it here? I want to get a liquidation preference. If the startup is liquidated, sold somehow, I want to get my money back first. So that's, yeah, super typical. A corporation's stock can be organized into classes, which must be defined in the certificate of incorporation. Most startups start off with one class of common stock, conveniently called common stock. When they raise venture capital, startups typically amend their certificate of incorporation to create a class of preferred stock, conveniently called preferred stock. The certificate of incorporation can also specify that the class of stock be further divided into different series. It is rare for common stock to be divided into series, but preferred stock is almost always divided into one or more series for each financing. A financing is usually referred to by the series of the stock that was created for that financing. For example, if a startup raises money by issuing shares from a new series called the Series A preferred stock, people would refer to that round of financing as the startup's Series A financing. Yep. So basically, like, different investors putting in money at different times get different levels of safety, different preferences. And that makes sense. A corporation cannot issue stock unless the board has approved the issuance and there are enough shares available for issuance. If the stock is of a particular class, then there must be enough shares of that class available for issuance. Similarly, if the stock is of a particular series, there must be enough shares of the series available for issuance. So this is where things start to get confusing, and I hope they clarify this. So there's kind of like this assignment concept, this issuance concept. So you have stocks, you have shares available, and then after that, you issue those shares to people, I believe is the right terminology. So hopefully they go over that, because it does get pretty confusing. The first step in determining how many shares are available for issuance is to determine the number of authorized shares. The number of authorized shares is the number of shares the corporation is authorized to issue. It is impossible to issue shares that have not been authorized. The number of authorized shares is set in the certificate of incorporation. If the stock of the corporation is divided into classes or series, the certificate of incorporation must set the number of authorized shares for each class or series, as well as the total number of authorized shares. Most startups authorize 10 million shares of common stock at formation. Then, to determine how many shares are available for issuance, take the number of authorized shares and subtract the shares that have been issued, as well as the shares that have been reserved for some other purpose. For example, for issuance under a stock plan. On the off chance the corporation has repurchased any shares, and those shares have not been retired, those shares would be added back as shares available for issuance. If a corporation wants to issue shares, but there are not enough shares available for issuance, it must file an amendment to its certificate of incorporation with the Delaware Secretary of State to increase the number of authorized shares. So I've run into this issue before. Let's look at the terminology. I was a little bit confused earlier because it's confusing. There are authorized shares. So your corporation will have 10 million shares authorized. That is kind of, or common, it could even be a particular class of share, as they said. You could have 10 million common stock authorized, and then 5 million preferred stock authorized, something like that. And then after you have those shares authorized, you can issue them. So I issue some to my co-founder, I issue some to myself, etc. And you can't issue more than you have authorized. There's 10 million shares authorized. You can only issue from that pool of 10 million shares. And if you want more to authorize, let's say a co-founder joins you and you want to give them 5 million shares, but I have 5 million, she has 5 million, we've used all of our authorized shares. You have to authorize more by filing an amendment to your certificate of incorporation with the Delaware Secretary of State. So you have to send a letter to the Delaware Secretary of State. I think I've done this, and it's a very short letter. You just have to say, look, I want 5 million more shares authorized, or this is my certificate of incorporation. It says we authorized 5 million more shares. Now you have 5 million more to issue. They don't talk about it here, but there's some tax issues associated with if you authorize more shares or if you issue. Actually, I think authorizing is fine. When you start to issue them, you can run into some tax issues. And I believe that's what they're going to talk about with the 409A valuation. This handbook is so good because it doesn't shy away from there's the legal issues, and then there's also some of the tax issues. And it talks a little bit about both and gives some advice on both. So that's very valuable. Contracts. Contracts are agreements that create rights and obligations enforceable by law. When you think of a contract, you probably think about a document that people sign. Many contracts are formed this way. However, contracts do not need to be in writing. You can create a contract simply by talking with someone else. Most attorneys recommend against creating oral contracts because they're unlikely to protect you as well as a contract written by an attorney would. You also don't need to sign a contract in order to be bound by it. For example, two parties can create a contract simply by coming to an agreement over email. Corporations rely on humans to enter into contracts. Before someone can enter into a contract on behalf of a corporation, he or she must have the authority to do so. In most startups, the board gives the CEO broad authority to enter into contracts and empowers the CEO to delegate that authority to others as they see fit. This is why contracts often ask for your title when you sign on behalf of a corporation. By specifying your title, you are indicating how you hopefully have authority to bind the corporation. That seems like obvious, but I guess it's good to state. When to form. To determine how to form a corporation, the founders typically consider the benefits set forth below. Personal liability protection. Forming a corporation protects the founders from personal liability. If the corporation is sued, the assets of its founders are more likely to be protected. Clarity with co-founders. When more than one founder is involved in a startup, the corporation formation process helps clarify and formalize the relationship between the founders. This is particularly true with regard to equity ownership and intellectual property ownership. Equity ownership. During the formation process, founders decide how equity ownership will be split. Additionally, founders often place restrictions on the ownership of their stock, some of which lapse according to a vesting schedule. Vesting incentivizes founders to work together for a certain period of time and also defines what happens to their shares if they leave the company before the end of that period. These early decisions help align interests and minimize ownership disputes. Intellectual property. The formation documents should ensure that the company owns the intellectual property, commonly referred to as IP, created by founders. IP is often at the heart of a startup's value, so it's important to make sure that the company can use the IP without any restrictions, even after founders depart. Yeah, so that's not part of, they didn't mention it, but typically it's a separate agreement. So it's part of all those documents when you first sign, but usually it's something pretty similar to what a software developer would get at a big company, where it says, hey, anything you do is owned by this company. And depending on how it's set up, it'll be within a domain, maybe. Especially if the founder is involved in multiple startups, they'll say anything relating to this is owned by the company. GitHub has a great intellectual property agreement that they issue to people. It's very, very lenient as far as what they're allowed to do. It says only things related to the company's domain are basically within the intellectual property of the company. I believe that's called GitHub's Balanced Employee IP Agreement. So that's a great one if you're looking for an IP agreement. But most likely if you work with a legal firm, they're going to give you one that's a lot more heavy-handed with regards to how much people own. A lot of them say all ideas, concepts, anything while you're employed by this company is owned by the corporation without a written reason from an officer why it shouldn't be owned by the corporation. If you have some secret sauce that is really important that doesn't get out there, you might want to spend a little bit of time on that and make sure that that's good and pick an agreement that's very specific about when it's being violated. Enables investment. When done properly, forming a corporation enables the business to receive investments from third parties. Startup investors generally expect stock or a security convertible into a stock. Forming a corporation requires an entity that is capable of issuing this stock. Okay, so they're already it's already getting a little confusing with regards to the things they're talking about that we might not know about. So it says a security convertible into a stock. What does it mean? So what it's referring to is also called, I believe, a financial instrument. So they're talking about things like Y Combinator's SAFE agreement. All right, one more time. Enables equity compensation. Corporations can create stock plans and offer equity compensation to employees and consultants. Equity compensation is often key in attracting and hiring top talent, so the ability to issue it is of a practical necessity. Optics. Finally, some founders find that having a legal entity is helpful in projecting an image of company maturity to potential customers, partners, or investors. Process. For startups, the typical steps for forming a corporation are incorporation, filing a certificate of incorporation signed by the incorporator with the Delaware Secretary of State, and then after that, post-incorporation setup. So once the Delaware Secretary of State accepts the certificate of incorporation, the incorporator adopts bylaws for the company, sets the size of the board of directors, and elects the initial board of directors. 3. The board of directors appoints officers and authorizes the issuance of shares to the founders. 4. The founders purchase their shares from the company and become stockholders. If their stock is subject to investing, the founders usually make 83B elections. 5. The founders enter into confidentiality and IP agreements with the corporation, known as CIIA or PIIA agreements. So I've never heard CIIA or PIIA, so I'm curious what that's about. And then I think we'll talk about 83B elections later, and I believe we'll also talk about CIIA agreement, a confidential information and invention assignment agreement, stock plan setup. 6. The board adopts and the stockholders approve a stock plan. Foreign qualification. 7. The corporation qualifies to do business in its home state, assuming it's not located in Delaware. So if you incorporate in Delaware, I guess you're all set in Delaware, and your business only operates out of Delaware. Regional differences. You might hear some people talk about the need to have a shareholder agreement. Startups following the standard process outlined above rarely need a separate shareholder agreement. Shareholder agreements are more commonly used by traditional small businesses, although some startup lawyers outside of major startup ecosystems use them as well. Yeah, I think I have used one. Getting help. It is important to make sure that company formation paperwork is done correctly. Unfortunately, it is practically impossible for most people to correctly complete the documents on their own, unassisted. This is true even when using forms or document generators provided by law firms for marketing purposes. Consequently, most startups use an attorney software, such as Clerky, or both. Software helps take care of the clerical aspects of the paperwork, while attorneys are useful for legal advice. Regardless of whether you are evaluating an attorney, software, or both, the most important criteria to consider are completeness and legal quality. Completeness is relatively easy to evaluate. All experienced startup attorneys will be very familiar with the full set of steps above. With software, it is important to make sure that the software will handle at least the full set of incorporation and post-incorporation setup steps. This is important because when software leaves the process hanging in the middle, it makes it more complicated to complete the company formation. The legal expense of doing so is almost always significantly greater than had the startup completed all of the first 5 steps together in the first place. It's hard for non-lawyers to discern the quality of legal paperwork. Absent obvious mistakes, issues with legal quality often escape detection until a VC or acquirer performs legal due diligence. Most startups never make it that far, unfortunately, so they will never find out whether their formation was done properly. Even when startups make it legal due diligence process, they usually don't publicize any issues that are discovered. All this makes it difficult to tell which lawyers and software produce high-quality legal documents and which do not. If you know fellow founders whose startups have raised or been acquired for a significant amount, one imperfect approach is to ask and see what lawyers or software they used without issue. Yep, so a company isn't going to say that they formed improperly if it was discovered in their round. They're just going to correct it as soon as possible. Not only because it might be embarrassing, but because it might put some of their contracts or something like that into troubles. They got to go and fix that as soon as possible, I would assume. Equity allocation. Often when forming a corporation, founders must decide how equity should be allocated. In order to do this, founders typically consider the relative percentages of the company each founder should own, a rough sense of what percentage of the company will be owned by employees and consultants, and whether or not they want to informally set aside shares for the possibility of entering an accelerator program, for example Y Combinator, or adding additional co-founders. Using the standard 10 million authorized shares, an example of a typical allocation would be 8 million shares divided among founders, 1 million shares to be reserved for issuance under a stock plan for employees and consultants, and 1 million shares informally set aside for accelerators or additional co-founders. The corporation can always amend its certificate of incorporation to authorize more shares. This requires additional time and legal expense, so founders typically try to allocate shares at formation in a way that minimizes the chance of subsequent amendment being required. I think for my first startup, we only issued 5 million shares, or we authorized 10 million shares, but then we only issued 5 million to our initial founders because we were expecting a lot of investment, maybe another co-founder, a lot of different things. So we were very open to that possibility, so we did not issue as many shares. Vesting. When a startup issues stocks to founders, they usually subject some or all of the shares to vesting. This means that even though the founders own their shares, the corporation can repurchase some shares if the founder ever stops providing services to the corporation. The number of shares the corporation can repurchase is limited to the number of shares that have not yet vested. So a lot of people misunderstand this process, so I'm really glad they phrased it this way. Usually the founder has all the shares, and then the corporation repurchases those shares back. So you actually do have the shares. You're not getting the shares slowly over time, but the corporation is allowed to repurchase them. So they can buy back your shares, but as time goes on, they're not allowed to repurchase as many, and that's the vesting. So that's a little confusing. The reason why you have to have all the shares and you don't get them slowly over time is you have all the voting privileges of those shares. Vesting is also used for stock or options issued to employees and consultants. When common stock is subject to vesting, it is referred to as restricted stock by startup attorneys. Restricted stock typically vests over time on a schedule known as a vesting schedule. The date when vesting begins is known as the vesting commencement date. The most popular vesting schedule by far is frequently referred to as the 4-year vesting with a 1 year. The most popular vesting schedule by far is frequently referred to as 4-year vesting with a 1-year cliff. Under this vesting schedule, 1/4 of the shares subject to vesting will vest on the 1-year anniversary of the vesting commencement date. This is the 1-year cliff. After that, 1/48 of the total shares originally subject to vesting will vest every month. By the end of the 4 years, all of the stock will have vested. So I've used something like this on all of my startups. Basically, the repurchase option for the company, the ability to take your shares away, goes away over 4 years. But for the first year, the company can take away all of those shares if you stop providing services. So that's a way of it. Usually, if there's a founder problem, it's in the first year. If the founder's like, I actually need to go work a job, I don't want to do this. That usually happens in the first year, and they can cause a lot of problems if they have some shares in your startup. So this is a way of making sure that that common scenario does not cause problems. The second most popular vesting schedule is the 4-year straight line vesting, which means that 1/48 of the total shares originally subject to vesting will vest every month. 4-year straight line vesting is the same thing as having 4-year vesting with a 1-month cliff. The vesting commencement date is commonly set to the date the shares are issued to the founder. If the founder puts substantial work into the startup prior to the stock issuance, it is not uncommon for the startup to give the founder some vesting credit. This refers to setting the vesting commencement date to an earlier date, often the date on which the founder started working on the startup full time. I had this happen to me for both my startups. I think I was working on it. I was the programmer and I built some technology prior to the startup taking off or actually launching. And so they said, okay, we're gonna give you you're gonna start receiving your shares a little bit earlier because it's kind of like you've been working on this a little bit longer. Vesting protects founders, investors, and employees. Consider 2 co-founders that have just begun work on a startup and have decided to split the equity evenly. If one co-founder leaves after just a week and his or her stock is not subject to vesting, the remaining co-founder and other employees could go on working for years and still have the same level of ownership as the departed co-founder. By subjecting the stock to vesting, startups avoid this kind of scenario. So vesting protects everybody, and that's why almost everybody uses it in my experience. For solo founders, if a solo founder does not already have vesting in place, investors will often require that a vesting schedule be put in place. Consequently, it is common for solo founders to impose standard vesting on their stock at formation in order to reduce their chances of ending up with less favorable vesting terms. For example, imagine a solo founder begins full-time work on their startup and does not subject their shares to vesting. Suppose that after months or years of work, the founder looks to raise money from an angel investor. The angel investor, seeing that the founder's shares are not subject to vesting, will probably require the founder to subject their shares to vesting, and may only allow for partial vesting credit or none at all. Had the founder's shares already been subject to a normal vesting schedule, the investor might not have raised the topic at all. That's a totally valid point. An investor is going to be like, you don't have vesting? That's huge. Like, get vesting, and then they won't give you favorable investing. If you already had vesting at the beginning, you're going to get the most favorable vesting, basically. So, great point. Sometimes if your vesting's close to done, the investor will still make you redo the vesting. So sometimes you can't get out of it. Investors, they're risk adverse in some sense. So, okay, here comes a really confusing one: 83B elections. So this is a very confusing concept, but it's absolutely essential for U.S. startups forming companies. It's probably one of the most important documents. Very easy to forget. Very big deal if you forget it. So, of course, they would go over this. So let's jump in. 83B elections. When shares are subject to vesting, by default, the IRS treats it as a taxable event every time a portion of the shares vest. This means that whenever you have shares of the stock vesting, the IRS considers as taxable income the difference between the fair market value of those shares at that time and the price you paid for those shares. And that's very important. It doesn't sound too important now, but the fair market value of your shares goes up over time, depending if you have raise events, which I assume is what they're about to talk about, but it's a really big deal to get that Section 83B in. For founders of successful startups, this can lead to significant increase in taxes as the fair market value of their stock increases. The taxable income is tied up in the form of illiquid stock, which makes it difficult for founders to be able to afford the tax increase. In addition, the process is likely to be a significant burden due to the number of times the fair market value would need to be determined. For example, for 4-year straight line vesting, the fair market value would need to be determined 48 times. Fortunately, the IRS allows recipients of restricted stock to elect alternative tax treatment through an 83B election. If you make an 83B election, you can disregard the vesting for tax purposes and consider the purchase of stock to be the only taxable event. You would then recognize the difference between the fair market value at the time you purchased the stock and the price you paid for those shares as income for the current tax year. Founders typically purchase their shares at fair market value, so if they make an 83B election, they typically do not have any taxable income from the purchase of their shares. So basically, when you start your company, the fair market value of your company is near zero. So it's not increasing over time. You're only paying the taxes relating to the fair market value at the time of your incorporation, which is basically zero. And so you don't have really any income tax as it goes. In order to make a valid 83B election, you must manually sign the 83B election. The IRS does not accept electronic signatures for 83B elections, and mail it to the appropriate IRS office within 30 days of the stock issuance. It is critically important to make the 83B election on time, as there is no easy fix to fix a missed deadline for an 83B election. So it's a very important piece of paperwork if you have a vesting schedule and you're and you just incorporated. You only have 30 days to deal with this 83B election, and it has to be mailed. IRS regulations also require you to provide a copy of your 83B election to the company. As a founder, providing a copy to the company can be as simple as emailing a copy to your co-founders, if any. It is considered a best practice to store all copies of 83B elections in the company's records. In addition to making a valid 83B election, it is important to get evidence that you've done so. VCs and potential acquirers will look for this evidence as part of legal due diligence process because missed 83B elections can cause startups a lot of problems down the line. In order to get all the possible evidence, most attorneys recommend mailing the 83B election to the IRS via USPS certified mail with return receipt requested. You should then retain the certified mail receipt as well as the return receipt when it comes back to you. In addition, most attorneys recommend including a request to the IRS to acknowledge the receipt of your 83B election. In order to do this, you should include a brief letter to the IRS along with a copy of your 83B election in a self-addressed stamped envelope. The IRS will then typically stamp the copy and send it back to you. Unfortunately, the IRS occasionally neglects to do this, or it gets lost in the mail, which is why it's important to retain the certified mail receipt and return receipt. So basically, this document is such a big deal, you should get essentially insurance on it by getting special postage. You really don't want it to come up where you didn't have this election in place and you had vesting, because then you're going to have a lot of taxable income for years and years that you probably neglected to pay. So it's a really important document. I wish the U.S., the IRS would make this process a little bit easier because it's so important. Capital contributions. Founders of a new corporation may contribute cash to the corporation to help the corporation start operating. Some founders are tempted to simply increase the purchase price of their common stock to get the desired amount of capital into the corporation when they pay for their shares. Most startup lawyers recommend against this approach because it can affect the fair market value of the common stock. The value of equity compensation for employees and consultants is tied to the difference between the common stock fair market value at the time of issuance and the price at which the equity is eventually sold. Therefore, startups typically try to avoid prematurely causing an increase in the common stock fair market value to maximize the value of the equity compensation. So basically, if you're going to give your consultants and your employees a good deal on stock, which you definitely want to do, you don't want to do anything that could trigger that equity in your startup for those stocks to be valued. That's one reason why investors use financial instruments, because they're not paying for the stock directly. And it's also a reason not to buy your shares at a high price. Instead, founders typically contribute cash to the corporation in the form of a simple loan. With a simple loan, the company would be obligated to repay the founder at a later time, along with a nominal interest, right? So just use a different financial instrument than paying for stock to give your company money. Alternatively, some founders structure the contribution as a seed investment in the form of a convertible note or SAFE. Founders should consider the impact of a seed investment will have on control and relative economic outcomes and any resulting side effects on working relationships. Some future investors may seek to undo a founder's seed investments if they feel the economics are too founder friendly. I've never done that. Issued myself a SAFE or a convertible note. I think that would complicate things. I don't think I would do that. Stock plans. To issue equity to employees and consultants, most startups set up a stock plan. A stock plan is a company program used to issue stock options or restricted stock to employees and consultants. Stock plans must be set forth in a legal document that is adopted by the board and approved by the stockholders. Startups typically set up stock plans as part of the corporate formation process, even if they don't have any immediate plans to hire people, because it is easier and cheaper to do all the paperwork at once rather than over time. So basically, you're going to set up a stock plan for all your employees for the next 2 years or 4 years, all at once. You don't want to have to deal with it for each employee that comes in. There are 3 primary benefits to using stock plans. When a startup sets up and uses a stock plan properly, the startup and its employees and consultants can benefit from advantageous tax regulations. Corporations must comply with securities regulations under federal and state laws whenever they issue any securities, such as stock or stock options. By default, a corporation will have to analyze securities regulations and potentially make filings each time it issues securities. With a stock plan, though, corporations only need to make the analysis and any necessary filings once per relevant state with respect to issuing stock or stock options to employees or consultants. So that line sounds scary, right? But basically what they're recommending is just have a stock plan, because then you only need to deal with it once. I don't know why they didn't say it simply like that. If you have a stock plan, you only need to deal with going through those regulations once. And I wish they would mention some of the regulations, because it's not all that scary if you're using a sort of pre-built stock plan, which a lot of people are going to use a pre-built stock plan. That said, stock plans are pretty complicated. I've gone through them with a lawyer before. And it can definitely be a little bit intimidating. So you actually kind of want to hold off on it if you can, which can be difficult if you're hiring people, because you basically need it as soon as you hire people. So it's definitely a point of tension early on. Like, how much time are we going to spend on a stock plan? By using standardized terms for all equity compensation, startups can reduce the amount of time and money they spend on legal due diligence in future financings and acquisitions. So basically, a benefit to having a stock plan is you have a very standard thing that your lawyers know how to read. You're not going to have to pay them to understand some custom document that you've created. And that's kind of an argument for doing it yourself. Don't just come up with something yourself. It'll actually cost you more. The name of a stock plan usually includes a year in which the stock plan was adopted. For example, if your startup adopted a stock plan in 2016, it would be named something like 2016 Stock Plan. This is done to distinguish stock plans from each other, since a corporation may adopt additional stock plans in the future, though this is infrequent. Like I said, you might have it for 2 or 4 years or something like that. You might even have it for longer. I don't know. I haven't really gotten to the stage where I was issuing multiple stock plans. When a corporation adopts a stock plan, it must specify the maximum number of shares that can be issued under that plan. The corporation can change this number later by amending the stock plan with an approval of the board and stockholders. The corporation must reserve that the maximum number of shares for issuance under the plan. The corporation must reserve that maximum number of shares for issuance under the plan and must have enough shares available for issuance in order to do so. The reserved shares are often collectively referred to as an option pool or stock option pool. So sometimes you'll have a pie chart of all the equity in your startup, and usually a slice of it is the stock option pool. It might be 10% or something like that, is like, oh, that's for future employees, and investors get that. Terminology. The following are also terms commonly used to refer to stock plans: stock option plans, employee stock option plans, ESOPs, ESOPs. I assume that's pronounced ESOPs. I don't know. It sounds right? Equity incentive plans. The term stock plan, as used in the context of a startup, does not typically refer to employee stock ownership plans, employee stock purchase plans. Okay, guys, so critical difference here. Employee stock option plans, that's what we're talking about, yes. Employee stock ownership plans, not what we're talking about. So the difference between the stock ownership and stock option, and they have the same abbreviation, and they actually used it here twice. Okay, so yeah, that could be confusing. So option versus ownership, those are different. Right now we're talking about stock option plans. These other types of plans have a very specific meaning and are not commonly used by startups. Note that employee stock option plans and employee stock ownership plans share the same acronym confusingly. We're going right through. So now this is now the first part of the third section. Fully diluted capitalization. When fundraising, the main topic of negotiation is often the pre-money valuation used to calculate the price of stock issued to investors. Pre-money valuation refers to the valuation of the startup prior to fundraising. The pre-money valuation matters because it determines the percentage of the corporation an investor will receive in exchange for their investment. Startup investors typically calculate their percentage ownership based on the fully diluted capitalization of the corporation. Capitalization in this context refers to the capital structure of a corporation, that is, the structure of the equity and the debt of a corporation. The term diluted refers to the fact that the ownership percentage represented by each share of the stock is diluted each time new shares are issued. The term fully diluted means that the capitalization is calculated assuming that all plans and obligations, whether outstanding or potential, to issue shares have been fulfilled. So I believe when we were talking about the stock option plan previously, it would be like, okay, if the stock option plan was fully executed, right? Because when you create it, 10% is in the stock option plan, but it hasn't been executed. It hasn't been assigned to employees yet. So when we talk about fully diluted, we're talking about all those shares have been issued. It's fully diluted, meaning it, like, the investor's investment has been diluted maximally by as many shares that have obligations have been issued, right? Because as the stock option plan gets executed, everybody is diluted. They own a smaller percentage of the company because there are more shares that have been issued. So, or assigned or executed. Stock options have been executed. So fully diluted means all those obligations have been executed. The employees got all their shares, etc. Thus, a startup's fully diluted capitalization commonly assumes all preferred stock has been converted into common stock, outstanding options, warrants, and other securities with a right to acquire shares have been exercised, and any shares reserved for issuance under a stock plan have been issued. So that's what I was just talking about with shares issued under a stock plan. But they also mention here all preferred stock has been converted into common stock. It's possible that common preferred stock can be converted into other things. I believe it can be converted into cash, right? The investor just wants cash, the cash back for their investment or whatever. So assuming it's all been converted into common stock, you're diluting the investor in every way possible, essentially. So the investor wants to know is what is the smallest amount I would own if I get all that dilution. There is no single definition of fully diluted capitalization. For example, unissued shares reserved for issuance under a stock plan can be excluded from a fully diluted capitalization. This is commonly done when fully diluted capitalization is being calculated in connection with the acquisition of a startup, since startups typically do not issue equity following an acquisition. By contrast, these shares are almost always included in a fully diluted capitalization in the context of equity compensation. Another difference is with securities that convert into stock in connection with a preferred stock financing, such as convertible notes and safes. Some definitions of fully diluted capitalization assume that the conversion of these securities. Some definitions of fully diluted capitalization assume the conversion of these securities, while others do not. The securities of a startup can almost always be ultimately converted into common stock, so it is common to see fully diluted capitalization expressed as a number of shares. Example, a startup with the following capital structure can be said to have a fully diluted capitalization of 8.5 million shares if unissued shares reserved for issuance under a stock plan are excluded. 8 million shares issued and outstanding, 1 million shares reserved for issuance under a stock plan for employees and consultants, of which 500,000 shares are subject to outstanding options, and 500,000 shares remain available for issuance, and 1 million shares informally set aside for accelerators or additional co-founders. If unissued shares reserved for issuance under a stock plan are included, then the startup could be said to have a fully diluted capitalization of 9 million. So in this example, they're pointing out some ambiguity in fully diluted capitalization. Sometimes you'll consider the shares available for issuance in the stock plan. Sometimes you won't. Sometimes you'll only consider the shares that employees can execute. I didn't know that was so ambiguous. Okay, convertible notes. One traditional way for a startup to raise seed financing is to sell convertible notes, also referred to as convertible promissory notes. These seed financings are known as convertible note financings. Related article. Although convertible notes have traditionally been popular for seed financings, the trend in Silicon Valley and other major startup ecosystems is towards safes and other alternatives. So a safe is the simple agreement for future equity agreement. Notes, also referred to as promissory notes, are promises made by someone to pay a specified amount to the holder of the note, also known as the note holder, at some time in the future, known as the maturity date. Convertible notes are notes issued by a corporation that convert into shares of the corporation's stock upon certain events. When a startup sells convertible notes, the notes typically obligate the company to repay the purchase price plus the interest in the event that the note has not been converted by its maturity date. Although they are notes, the startup and the investor, i.e. the note holder, usually intend for the note to convert into stock, rather than for the corporation to repay the note. Typically, the convertible notes convert into shares of a series. I'm going to redo this because I hate when I say IE instead of that is. It should be that is. I just forget. Although they are notes, both the startup and the investor, that is the note holder, usually intend for the note to convert into stock rather for the corporation to repay the note. Typically, the convertible notes convert into shares of the series of the preferred stock issued in the corporation's next equity financing as part of that equity financing. Convertible notes often also convert into shares of the corporation's stock if the company is acquired or does an IPO. Most convertible notes have features known as valuation caps or discounts, which affect the number of shares the note will convert into. Valuation caps and discounts are explained in our article about safes. Despite their popularity, many people consider convertible notes awkward to use. Even though investors and startups do not typically think of convertible notes as an obligation of payment, they must agree on an interest rate in order to issue a convertible note. If a note has not converted by its maturity date, the investor and the company must spend time and energy deciding what to do, usually extending the maturity date. These problems exist because convertible notes were not originally designed for seed financings. They were designed for bridge loans, loans made by VCs for companies they invested in to help those companies survive until their next round of venture capital financing. Startups began using convertible notes for seed financings because the paperwork and negotiation was considerably simpler than for equity financing. Recently, various organizations have created alternative forms of investment designed for seed financings from the ground up in order to address the problems with convertible notes. In Silicon Valley and other major startup ecosystems, these alternatives are gaining popularity over convertible notes. Safes and others. The most popular replacement for convertible notes are safes, which are short for Simple Agreement for Future Equity, created by Y Combinator. Like convertible notes, safes can convert into preferred stock. Types. There are three major types of safes: safes with a valuation cap, safes with a discount, and safes with both. These correspond to the three major flavors of convertible notes. Valuation cap. When a safe converts into preferred stock, the conversion price is used to determine how many shares the safe converts into. The conversion price is typically calculated in the same way that the price per share of the preferred stock is, by default. That is, by dividing the pre-money valuation by the fully diluted capitalization. For example, if the investment amount is $1 million and the price per share of the preferred stock is $1, the safe would convert into 1 million shares by default. Valuation caps are a limit on the pre-money valuation used to determine the conversion price. By limiting the pre-money valuation, valuation caps ensure that safes will convert into a minimum percentage of the company as calculated prior to the preferred stock financing. There is no floor on the percentage of the company that the safe holder ultimately ends with, however, since that depends on the amount invested by others in the preferred stock financing. For example, if someone invests $1 million through a safe with a $10 million valuation cap, the safe will never convert into a number of shares that represents less than 10% of the company prior to the preferred stock financing. If the company sold preferred stock at a $20 million pre-money valuation, the safe would convert into $2 million worth of shares. Valuation caps are also referred to as conversion caps or target valuations. Yeah, that's like, informally, that's what they say, like, what were you valued at for that financing round is the valuation cap, because that's what they believe you'll be valued at more than that in the future. Yeah. Basically, if you're valued at a certain amount for one financing round, for the next financing round, you better be valued at more. Valuation cap and discount. Some safes have both a valuation cap and a discount. When safes with both a valuation cap and discount convert, the more investor-favorable method is used. That is, the method that results in the safe converting into more shares. So the investor chooses how that instrument, that financial instrument, will convert. Wait, what? How would it work differently than the example? Green asks. So basically, there are two scenarios. That's a great question, by the way. Let me see. You said that at 2:49. Okay, so this was a little while ago. So basically, if the company sold at for example, a $5 million pre-money valuation, the safe would convert into more shares. Is that right? So basically, let's say in your next financing round, you have you sort of establish a valuation cap that's lower. The investors in your previous round are going to get more shares. That's the intuitive understanding. Every round, you have to raise more and more money. And what these convertible notes do is protect investors from that valuation going down. If that valuation goes down, they're going to end up getting more shares. So that's why it's a valuation cap. That's the intuition behind it. I'm not sure about their phrasing here or how to change the example. Just because I would want to actually do it out. These ones, I'm kind of reading those examples without computing too much. Okay, I don't think I did this one yet. Valuation cap and discount. Some safes have both a valuation cap and a discount. When safes with both a valuation cap and discount convert, the more... I did already read this. Less number of total shares when the valuation was estimated to be lower. Less number of total shares. No, well, okay, so terminology we have to be careful about. So I know when I was... So this stuff is very confusing, first of all. But I know when I was raising money, I was particularly confused about the word total shares. So you can talk about authorized shares, which is what most people... When they say total shares, that's usually what they mean, right? In the case... And also consider the company can own more shares than it has authorized, more than its total shares. It can in some sense owe more than that. It will have to issue more share, or it will have to authorize more shares in order to issue those shares. So it can be obligated to give that investor more shares than it has available. You certainly don't want to be in that situation. Something went very wrong for you to be in that situation. And maybe you don't have to do it. Maybe you can say, okay, that convertible note is going to convert into cash instead, or maybe you don't have to execute that convertible note. It's usually not in the investor's interest to destroy the company over a financial instrument. So, and the financial instrument hopefully protects the company from that anyway. But these convertible note agreements, like, they're kind of brushing over the general topic, but these convertible note agreements are pretty straightforward. I would actually pull up an example if I had more time, and also I had one handy that didn't disclose all my startups financing. I'm sure I have a blank convertible note, but they're pretty straightforward. Everybody has an idea of what they'll get in the success scenario, and nobody really worries about the downside scenario too much. Not at early stage financing. Why did I drink a carbonated beverage? Makes no sense. I'm like burping while I read all this. Acquisition. By default, if a safe has not already converted by the time the company is acquired, the investor has a choice of receiving their investment back or having the safe convert into common stock using the same valuation cap or discount as for preferred stock conversion. When investors have significant negotiating power, they may negotiate to have the safe specify an option to receive a multiple of their investment back, typically 2x. This has the effect of increasing the minimum acquisition price at which the founders and employees will receive proceeds from an acquisition. Yep, that's true. An investor doesn't want to get their money back. They want to get more than their money back. So they might say to a founder, look, if you're getting acquired and I'm just going to get my investment back, that's not a good deal for me. So I'm going to require a higher conversion for that preferred stock if it converts to cash. Other notable convertible equity forms include the KISS, created by 500 startups. I actually don't know the KISS. Let's take a look. Keep it simple security. I don't know if that's visible. Keep it simple security. Okay, so obviously there's a lot of text here. I'm not going to read into everything, but it might be worth looking into. Preferred stock. While most startups issue convertible notes or safes in seed financings, some issue preferred stock, which is the standard for post-seed financings. Financings where the startup sells preferred stock are known as equity financings, since the preferred stock is a form of equity. Typically, startups create a new series of preferred stock for each equity financing. Startups issuing preferred stock in seed financings will usually call the new series Series Seed or Series AA. These financings often use forms based on those used in post-seed financings, but that are specifically adapted for seed financings. By convention, for post-seed investments, the series are designated by letters in alphabetical order. For example, the series created for the first post-seed financing is typically called the Series A preferred stock. The series created for the next financing is usually called Series B preferred stock, and so on. And I've seen it, like, it goes up to F, can go on and on and on. And then at some point, the company goes public, right? I've also seen pre-seed, which they don't say here. For some reason, they don't say that. This is now the hiring section. Employees and consultants. The people you hire. Let me adjust my mic here. Oh. Employees and consultants. The people you hire to work at your startup will be either employees or independent contractors, commonly referred to as consultants by startups. When startups hire employees, they typically have the employees sign offer letters. When startups hire consultants, they usually enter into consulting agreements or independent contractor agreements with the consultants. For both employees and consultants, startups should enter into agreements to make sure that 1, the worker is bound to confidentiality, and 2, the company owns the IP that the worker creates. These agreements are typically called confidential information and assignment These agreements are typically called confidential information and invention assignment agreements, CIIA agreements, or proprietary information invention assignment agreements, PIIA agreements. Classification. At the federal level, the U.S. Department of Labor and IRS have separate criteria for determining whether someone is an employee or consultant. Under Department of Labor guidelines, whether someone is an employee or consultant typically depends on whether that person is economically dependent on the employer. The Department of Labor generally looks at 6 factors to determine whether someone is economically dependent on an employer. 1, the extent to which the work performed is an integral part of the employer's business. 2, whether the worker's managerial skills affect his or her opportunity for profit and loss. 3, the relative investments in facilities and equipment by the worker and the employer. 4, the worker's skill and initiative. Both employees and independent contractors may be skilled workers. 5, the permanency of the worker's relationship with the employer. And 6, the nature and degree of control by the employer. This is how the IRS looks at the degree of control and independence. From the IRS, facts that provide evidence of the degree of control and independence fall into 3 categories. 1, behavioral. Does the company control or have the right to control what the worker does and how the worker does his or her job? Financial. Are the business aspects of the worker's job controlled by the payer? These include things like how the worker is paid, whether expenses are reimbursed, who provides the tools, supplies, etc. Type of relationship. Are there written contracts or employee-type benefits, that is a pension plan, insurance, vacation pay, etc.? Will the relationship continue, and is the work performed a key aspect of the business? Businesses must weigh in all of these factors when determining whether a worker is an employee or independent contractor. Some factors may indicate that the worker is an employee, while other factors indicate that the worker is an independent contractor. There is no magic or set number of factors that makes a worker an employee or independent contractor, and no one factor stands alone in making this determination. Also, factors that are relevant in one situation may not be relevant in another. Various states have their own criteria as well. You should check with the state where your startup is located, as well as any states where you hire people, to see what their criteria is. Note in that most cases, the classification does not depend on the term or documents used by the startup. A government agency may classify someone as an employee even if you refer to them as a consultant and have them enter a consulting agreement. The penalties for misclassification can be serious. Minimum wage. Federal law typically requires that employees be paid at least the federal minimum wage, and some states, including California and municipalities, have implemented their own higher minimum wage standards. The minimum wage is a cash standard, so companies can't use stock or options to satisfy this requirement. This means that startups cannot legally pay employees in equity compensation alone, even though many startups still do this. Federal law has an exception for employees that own 20% or more of a business, which can apply to founders if certain conditions are met. However, not all states with minimum wage laws have a corresponding exception. For example, California's minimum wage laws do not have such an exception. This means that California's minimum wage applies to founders in California, even when the federal minimum wage does not. Prior agreements. Some people may have entered into contracts that restrict their ability to work as employees or consultants. For example, a person who is a full-time employee at one company may actually be contractually prohibited from working at another company at the same time. Advisors are a type of consultant. Startups typically enter into an advisor agreement with them, which roughly covers the same topics as a consulting agreement and a CIIA agreement would. Interns. Paid interns are a type of employee. To hire a paid intern, a startup must use an offer letter and CIIA agreement just as they would with any other employee. It is almost always impractical for startups to have legally unpaid interns. Under Fair Labor Standards Act, as interpreted by courts, unpaid interns are only permitted when the employer derives no immediate advantage from the activities of the intern, and on occasion, its operations may actually be impeded. So don't take an unpaid intern. Sure. In my opinion, you might not want to take an intern at all. I've had bad luck with interns. I think interns are for more established companies, not an early stage startup. I've never seen it work out. The startups that had interns, sometimes they help a little bit, but just the overhead of teaching someone it's difficult to do that while you're trying to grow a business. The odds are against you. Equity compensation. In addition to salaries, a significant component of compensation in startups is in the form of equity issued under a stock plan. There are 2 primary forms of equity compensation: restricted stock and stock options. Restricted stock, as the term is used in startups, is common stock that is subjected to vesting. As with founders, employees who receive restricted stock will typically want to file an 83B election. Startups can either sell shares of restricted stock or give them to people for free. If a startup sells shares below their fair market value, the recipient must include the difference between the purchase price and the FMV as taxable income. If they give the shares for free, the recipient must count the FMV of the shares as taxable income. So the FMV is the fair market value. If you get shares for free, you have to pay that fair market value as your taxable income, and you have to pay any difference of it. Basically, it's like somebody gave you an asset, right? It's worth something. At the very beginning, it's worth very little. So if you get into a startup early, the difference is not going to be high, but that's the problem with joining a startup late. Your stock options you have to pay for. They're an option that you pay for. And if you came in late, say you joined Amazon 2 years ago, that was worth something. It wasn't not worth anything. So you have to pay what the difference in taxable income for that fair market value. Some people use the term RSU, short for restricted stock unit, synonymously with restricted stock. However, RSUs are not restricted stock. Instead, they are promises to issue restricted stock at a later time. RSUs are not commonly used by early stage startups. So it sounds like don't use RSU. It's not what you mean, probably. Stock options, also simply referred to as options, are a type of security that allows people to purchase common stock at a fixed price, known as the exercise price or strike price, in the future. People that own stock options are known as optionees. Purchasing shares through a stock option is known as exercising a stock option. Until they exercise the stock option, the optionee does not own the shares underlying the stock option. Thus, someone who only owns a stock option and no shares is not a stockholder. So this is a common confusion. Founders actually own that stock and the company has a repurchase agreement. With stock options, you have to pay for those stocks. You don't own that. You can't vote, for example, in a shareholder vote because you don't own it. You have to pay for it. And when you pay for it, you're going to have to pay something like that fair market value. So it seems a little unfair to people who are employees and they're like, wait, I have to pay just to get my options? Yes, but if the fair market value has gone up since you were issued those stock options, you'll have to pay less than what they're worth, so you'll get free money. But that's very difficult. This is something that's very relevant to employees. It's not the company imposing this on you, really. It's unfortunately just how the tax law in the U.S. works. And there's good parts to it too, right? I mean, otherwise, it's there for a reason. Stock options typically are subject to vesting, similar to restricted stock. Regular stock options can only be exercised to the extent that the underlying shares have vested. For example, if a regular stock option is only halfway vested, the optionee can only exercise the stock option for half of the shares covered by the stock option. A special type of stock option, known as an early exercisable stock option, allows the optionee to exercise before the underlying shares have completely vested. When an early exercisable option is exercised early, the unvested shares sold to the optionee are subject to a right of repurchase until they have vested. You can read more about early exercisable stock options in this blog post by Yokom Taku. So that's pretty interesting. I've never heard of that, but that makes them a lot more similar to restricted stock. You have the ability to vote, but the company can repurchase. But that's still not something I would give a founder because it sounds more complicated than the typical restricted stock option where you just file that Section 83B. With stock options, recipients must pay for the shares but do not need to do so until they decide to exercise the stock option. To comply with a set of tax requirements known as 409A, the exercise price of a stock option must be at least the fair market value of the shares at the time the stock option is granted. Often, startups start off by issuing restricted stock to avoid dealing with the 409A, and then switch to issuing stock options as the fair market value increases. This is because the fair market value of a startup's common stock usually starts low and grows over time. As the fair market value increases, restricted stock becomes less affordable for employees and consultants. Even if the startups give the shares for free, the tax burden can often be too large for people to bear. Percentages and shares. When offering equity compensation, startups commonly describe the offer as a percentage. For example, a startup might offer a prospective employee 0.25% of the company. Most attorneys recommend against this common practice, even if the offer is verbal. This is because stating equity compensation as a percentage can lead to confusion and conflict in the future for a few reasons. There are multiple ways to count the total number of shares in the corporation, and consequently multiple ways to calculate a specific number of shares based on a given percentage. Even when everyone agrees on one method of calculation, the resulting number can change in the time between when an offer is made and when the actual equity is actually granted, and some people may not realize that their percentage ownership can be reduced by future dilution. By convention, percentages typically refer to the percentage of the startup's fully diluted capitalization measured as of a particular date. I'm streaming this for people watching on YouTube, and somebody in the chat started talking about total shares. And what I said was, it's hard to answer the question because total shares is not a very specific concept when you're talking about stocks. There's a concept of authorized shares, which you talk to Delaware in this case. If your company is incorporated there, you talk to Delaware to get more authorized shares, and those don't really matter too much. But it's how many you are allowed to issue. You have the shares that are currently issued. You have shares that are locked up in financial instruments. You have stock options that could be executed. And so it's very difficult to say what the percentage actually is. And I've run into this problem when we were trying to negotiate with investors or talk to a co-founder who we are maybe buying back some shares because they left. You have this problem where not everybody is on the same page about what the percentage is. And it's very difficult to talk in terms of percentage. It's much better just to lay out where the stocks are, where they're locked up, and kind of compute it that way. Now, the best, instead of saying total shares, what you can say is the fully diluted capitalization. And that's much better because it implies a little bit more about how you could calculate the quote-unquote total shares, but it's still not that specific. As we went over earlier, the fully diluted capitalization doesn't necessarily specify how to take into account unexercised shares on a stock option plan or something like that. Okay, for example, a startup has a fully diluted capitalization of 10 million shares on a given date. If the startup offers an employee 25,000 shares on that date, the shares would commonly be said to represent 0.25% of the company's fully diluted capitalization as of that date. When making an offer to a prospective employee, startups can help illustrate the value of the number of shares being offered by providing the information necessary to calculate a percentage at a given point in time. For example, you want to offer a prospective employee 0.25% of the company. The fully diluted capitalization of your company at this time is 10 million shares. Therefore, the offer should be for 25,000 shares. You would tell the prospective employee that the equity compensation component of the offer is 25,000 shares. Then, to help the prospective employee understand the value of that number, you can tell the prospective employee that the current fully diluted capitalization of the company is 10 million shares. So the 25,000 shares would represent 0.25% of the current fully diluted capitalization of the company as of that conversation. Now, isn't that simpler? Their first question is going to be, what's a fully diluted capitalization? Or maybe they won't say anything because they're just happy to get an offer. Ultimately, without seeing the table, it's very difficult to know how much it is. And I understand why people are against kind of giving employees shares sometimes because they don't understand it. The founder of Basecamp, for example, he doesn't like to give shares to employees of the company. It is confusing. Without knowing all the options and all the other things that are going on. But at least this is more specific, right? You're not really lying. You're not going to confuse them. They're not going to calculate it wrong. Say you do a new fundraising round and you raise for 100 million. If they thought they had 0.25%, they might be like, oh, I'm a millionaire all of a sudden. Or something like that. But at least if you say it in this way, maybe they'll think twice and they'll be like, maybe I should look up. He was really emphasizing current, so maybe I won't think of him. I'll know it's worth something, but maybe not as much as I think. Still, it's not perfect. Actually, I think a graphic or an infographic would be helpful there. My favorite part, guys. 409A. Section 409A of the Internal Revenue Code, referred to as the 409A, imposes stiff penalties for issuing of stock options with an exercise price below the fair market value of the shares at the time the option is granted. The safest way for startups to comply with the 409A is to obtain a 409A valuation from a qualified independent appraiser when they are ready to issue stock options. A 409A valuation attempts to determine the fair market value of the startup's common stock as of a specific date, known as the valuation date. IRS regulations provide safe harbor for 409A valuations obtained from qualified independent appraisers. The burden of proof is on the IRS to show that they are grossly unreasonable. Without the 409A, it would be up to the company to prove that the exercise price of the stock option was not grossly unreasonable. Okay. A lot to unpack there. I have dug into this quite a bit because we authorized some shares pretty late in the game. We also did some late stock issuance. And so this is the fuzziest part of stock options and the whole deal. It's very confusing for people because it is a very gray area part of this. From my opinion, I'm not a lawyer, but I do not think there's a lot of strong history to show startups how to do this well. So let's look at some different things that they said here. It says IRS regulations provide a safe harbor. What is a safe harbor? That means you won't be sued by the IRS directly. Basically, you're a little bit protected. Let's see what they say by definition, so that I'm not too off here. Safe harbor, the space created by clear boundaries and laws and regulations designed to provide people with certainty about how to comply with a given law or regulation. Typically, the actual boundaries of the law or regulation are more permissive than the safe harbor, but also harder to discern. Okay, so basically, if you go to a, let's see what they call it, qualified independent appraiser, so this is going to be a company that will sell you a 409A valuation, they'll give you safe harbor, essentially. You'll pay them something like $10,000, and they'll say, okay, your startup's worth $3 million. We looked at your records, we looked at your fundraising, we looked at your convertible notes. You're worth about this much. Or you're worth this much. You now have safe harbor. As long as you didn't lie to that appraiser, you will not get in trouble later for issuing your stock options below the fair market value price. So basically that appraiser is determining what price you issue those stock options at. Without going to that appraiser, which we ended up doing, we ended up not going with an appraiser. You have to, if the company has to prove the exercise price of a stock option was not grossly unreasonable if something comes up later. So you have to say, look, we looked at our stuff, and you have to have proof that you did not give some low price, some favorable price to your employees to buy those options. So most people go to the qualified independent appraiser. They don't want to risk it. And investors do not like it when you risk it because they see a legal battle in your future. But those can be expensive. Early on, you don't have to worry about this. For example, you don't need a 409A if you just incorporate it. There's no need for it. You can do the fair market value of your company. It's nothing. It's fine. Whatever people paid for the common stock, probably like 1/100th of a cent. Perfect. No need to go worry about all this. No need to pay somebody $10,000 to do that. And even there's tools now where you can pay $100 if you don't have any financial instruments. You can go online and for like $100 you can get a 409A valuation, but they might overestimate. So at the very beginning, those restricted stocks are fine. That's what lawyers will probably tell you, from my experience, right? I'm not a lawyer, and this isn't legal advice, but it's hard to get a sense of this, and you don't want to spend $10,000 on a lawyer a lot of times, right? So from my experience, they'll just be like, your company's not worth anything. No fundraising, no nothing. After that fundraising, it's time to start maybe looking at those 409As, especially if you're issuing a lot of stock. And usually that you can come up with a fair market value that will be safe, but you don't want it to be that high, right? So if you just raised from investors at a $3 million valuation, for example, but on a convertible note, your stock still has never been valued. The last valuation event of your stock was probably when the founders bought it for nothing. So even though you've raised a $3 million or maybe $100,000 on a $3 million valuation for your round, valuation cap for your round, your fair market value isn't clear. It's less than $3 million, most likely. There's only $100,000 in the company, and the investors valued that valuation cap is for some point in the future, not now. So it can get quite tricky, and it's kind of how much risk do you want to take, and it's not totally clear. So I'm glad they provided some clarity here, but it's pretty clear also that that they would recommend going with the independent appraisers if you want that safe harbor. I mean, I guess they're not getting into too many specifics of when you should do it, and rightfully so, because it's going to be different, and they would take on a lot of liability if they did. But at some point, you'll probably be reading a lot about this if you don't have that much cash to get an independent appraisal, and you want to create a stock option plan and issue stock options. Lawyers will have a good sense of it. So if you talk to a lawyer, maybe you won't have to go to that independent appraiser if you're talking to a startup lawyer. Okay, enough on that. 409 valuations from independent appraisers are valid until the earlier of 1 year anniversary since the valuation date, or the occurrence of an event that would materially change the value of the corporation. After a 409A valuation becomes invalid, the startup would need to obtain a new 409A valuation in order to continue issuing stock options under the 409 safe harbor. As startups get more mature, they typically have accounting firms perform financial audits. Audit firms often require the companies to get prior 409A valuations redone by new appraisers if they have doubts about the quality of the initial evaluations. Thus, when selecting an independent appraiser for a 409A valuation, you should try to get a sense of how their valuations have held up under the scrutiny of audit firms. So they're more respectable appraisers, basically. Vesting acceleration. Vesting acceleration provisions enable vesting to be fast-forwarded when certain conditions are met. There are two broad categories of vesting acceleration: double trigger and single trigger. The number of triggers refers to the number of events that have to occur in order for the acceleration to kick in. If someone has double trigger vesting acceleration, commonly referred to as double trigger acceleration, on their stock or stock options, that typically means that the vesting will accelerate if 1, the company is acquired, or 2, that person is terminated in connection with or following the acquisition. This is the most common type of double trigger acceleration, although there are many other possibilities. For example, some double trigger acceleration provisions only allow for the acceleration of vesting for a certain percentage of shares, or more rarely, the triggers themselves may be different. So yeah, I have a single trigger acceleration. You know what they're not saying right now is this is for protecting the founders. Usually, you can use it for protecting anyone. But basically, like, if the founder gets the company to acquisition really quickly, they should be rewarded. They shouldn't get less shares. So that's what accelerates the vesting. So it's just a protection because, like, you know, your vesting is for 4 years, right? So if you get acquired in 2, great job. Your investors probably made out really well. So let's accelerate your vesting, give you more shares, give you the shares that you should own. The most common form of single trigger vesting acceleration, commonly referred to as single trigger acceleration, is for vesting to accelerate if the company is acquired. A far less common form of single trigger acceleration is for the vesting to accelerate if the stockholder is terminated. Double trigger acceleration is standard for stock issued to founders and is occasionally used for executive level hires. It is not typically given to other employees or consultants because it is viewed as undesirable by acquirers or consequently VCs. Naturally, single trigger acceleration is viewed as more undesirable. Single trigger acceleration is usually only given to advisors, if at all. Maybe I do have double trigger. I don't know. Don't remember. Not really a big deal at this point for me. I've been doing my current start for quite some time. Caution, you should consult an attorney before giving anyone any form of vesting acceleration. Aside from double trigger acceleration for founders, vesting acceleration is uncommon and should be used with caution. I guess I probably have double trigger then. Oh, we got through it all. Okay, so that is Clerky's guide. Yeah, maybe I wonder if I could go through the so let's look at some of the terms that were used in this, try to get an understanding of them. I don't know what all these are, so I'm going to learn something most likely. Asset, anything with economic value. Assets can be intangible, for example, intellectual property. Assets can be thought of the counterpart to liabilities. Authorized shares, number of. The number of shares the corporation is authorized to issue. So a lot of people think total shares when they think authorized shares. The company was incorporated with 10 million shares. That means it was authorized 10 million shares. But I think the trick here is don't ever say total shares. You can say fully diluted capitalization, and that gives a sense of the number of shares that are part of the stock plan, exercised, etc. But saying total shares is very vague. It's best not to do it. Authorized shares is the correct terminology there. B Corp, a for-profit corporation certified to meet certain rigorous standards of social and environmental performance, accountability, and transparency. The certification is administered by B Lab, a nonprofit organization. Okay. Bylaws. The bylaws of a Delaware corporation are a set of rules and procedures for how the corporation operates. These bylaws work with the certificate of incorporation to supplement Delaware law, which also specifies how corporations can operate. For startups, bylaws are highly standardized and customization is unusual. Changing the bylaws of a corporation requires approval of either the board or the stockholders. Yeah, so everybody I know, they have the same bylaws, basically. Everybody uses the same template. I don't know why you would customize your bylaws. Probably if you're really into business and you're trying something weird because you know a lot about it. But generally speaking, I don't think you want to. Capitalization, the capital structure of a corporation, that is the structure of the equity and debt of a corporation. Certificate of incorporation, the document filed with the Delaware Secretary of State in order to form a corporation. The certificate of incorporation specifies the types of stock the corporation can issue and how many shares can be issued. The certificate of incorporation can be changed by filing an amendment with the Delaware Secretary of State. Amending the certificate of incorporation typically requires the approval of the board of directors, and depending on the changes being made, may require stockholder consent. On occasion, startups may have separate contractual obligations that require the consent of additional parties for certain types of changes. Yeah, I think that's the first document you file. Charter, synonym for certificate of incorporation. Didn't know. Corporate charter. CIIA agreement, confidential information and invention assignment agreement, also abbreviated CIIAA, sometimes mistakenly referred to as CIIAA agreement, effectively synonymous with PIIA agreement, which stands for proprietary information and invention assignment agreement. This is something you would give to employees and consultants. Common stock, the default type of stock that corporations typically start off with. Common stock is typically issued to founders, employees, and consultants, and is typically not issued to investors. Okay, so convertible note. I think we've gone over most of these. C corporation, the default type of corporation. The C refers to subchapter C of the tax code. C corporation status means the corporation will be taxed as a separate entity apart from its stockholders. Yeah, so sometimes you hear about LLCs. They didn't talk about LLCs here. They're not really preferable for raising money. So if you're like a Y Combinator accelerator type startup, you're probably going to want to raise money. And so in LLC, the taxes work differently. It's not taxed as a separate entity. You can be taxed through the owners. It has pass-through income, I think. I'm not familiar with it because I only formed one LLC and it was a long time ago. And we didn't really have too many problems. So sometimes people will tell you that a LLC makes a lot of sense. If you're raising investment, my thought is just don't do it. If you're planning on getting a lot of investment, just don't do it. I had an LLC that we had to convert into a C Corp, actually. So I started an LLC, had to convert it into a C Corp because we couldn't get investment. We couldn't get into an accelerator. And it's very costly to do the conversion. So just don't do it. So a lot of people will say, oh, you'll save like $500,000 a year. And that's probably true. You might even be able to save more because there's this thing that happens with C Corps called double taxation, where the corporation will be taxed and then you'll be taxed for receiving income from the C corporation. And you can avoid that at the early stage by being an LLC, only at the early stage, as far as I know. Yes, $500,000 a year more. That sucks. I hate it. But the cost to fix it, right, is a lot more. Talking $10,000 plus. At least if you're working with the startup lawyers I was working with in Boston. So, Delaware C Corporation, a C corporation incorporated in Delaware. Delaware Secretary of State, the agency and the Delaware state government responsible for registering corporations. Dilution, the reduction Dilution, the reduction of value of shares of stock as a result of the corporation issuing more shares. Dividend preference, the right to be paid dividends before other stockholders are. It is uncommon for startups to issue dividends. Guys, even public companies like Tesla, maybe probably a couple others, I don't really care, they don't issue dividends. They don't pay their investors any portion of profit because, their argument would be, we're in a growth stage. We're going to make much more money if we invest all of our money in ourselves right now. I think for older corporations, maybe IBM or something, they'll pay dividends. But dividends are kind of uncommon nowadays. Maybe they'll be more common in the future. In this age of speculation, one might say. Early stage startup, for the purposes of this handbook, startups that have not yet raised Series A financing. Equity, synonym for stock. Equity financing, financing in which equity is issued as opposed to other types of securities such as convertible notes or safes. Exercise price, also known as strike price, in the context of a stock option, the price at which the underlying stock can be purchased by the holder upon exercising the stock option, that is, choosing to use it. So, if you're an employee, the price that you buy a stock option at is the exercise price or the strike price. So people will talk about that. If you get some stock from your company, people will talk about that exercise price. Fair market value, a value a given asset would fetch in an open market, assuming no information asymmetry. Of course, you can't just buy and sell shares on the open market, really, if you're a startup. Some rules against that. You have to be on the public market to just buy and sell willy-nilly. So fair market value is this very sort of in some sense broken concept, I think. It's like independently evaluated at what the market would pay if it was public. So our system isn't quite perfect for it, but that's exactly what this guide is about handling. Foreign qualification, the process of registering, also known as qualifying, to do business in a state other than the one in which the corporation was incorporated. Since most startups are Delaware corporations but are not located in Delaware, most startups must foreign qualify in at least their home state. And they link to the process chapter, which goes over like the 7 steps or whatever to incorporation. Founder, a term generally used to refer to the people who play a main role in starting a company. This term does not have any legal meaning. Yeah, in like the startup I'm a part of now, I wasn't there when the LLC was founded. I was there when the LLC was converted into a C Corp, but they still call me a founder. I think like when you get the fundamental people together, the business under it can change, but if the people don't, well, there's your founders. And I know people who have gotten founder, like quote unquote, the founder title like 3 years after. Initial public offering, the first time a company offers securities to the public. Due to securities regulations, it is extremely expensive to do an IPO. Consequently, it is typically only done by mature companies. Yep. Legal due diligence, the process a potential investor or acquirer goes through to determine if a startup has any legal issues that may affect its value. Typically, this involves an investor or acquirer having their attorneys review the startup's legal paperwork. Issues discovered in due diligence may affect the valuation of the company or the viability of the deal altogether. Legal entity, a non-human legal person. So person is we learned at the very beginning, person is a term that can be used for legal entities. A natural person is not a legal entity. That is, or I guess it is a legal entity, but it's a human. Legal person can be a corporation. Liability, used in a legal context, legal responsibility for something. As used in an accounting context, an obligation to pay something in the future. Liquidation preference, a right to receive proceeds from an acquisition or shutdown of the corporation before other stockholders do. From a founder's perspective, a liquidation preference for investors creates a minimum price that must be reached before the founders and other common stockholders will receive proceeds from an acquisition. Pending B Corp, a temporary designation for a for-profit corporation on the path to becoming a certified B Corp. I don't know why you would become a certified B Corp. I'm assuming they're going to talk about it in the future. I don't know yet. Pre-money valuation, in the context of a given financing, the valuation of a company prior to that financing. Preferred stock, one of the two types of stock that startups typically issue. Preferred stock has additional rights and privileges that common stock does not have and is typically only issued to investors. Quorum, the minimum number of directors required to be present at a board meeting in order for the board to act. Restricted stock, as the term is used by startups, common stock that is subject to vesting. Retired shares, shares that have been issued by the corporation and subsequently repurchased by or forfeited to the corporation and retired by the board of directors. Typically, once shares have been retired, they cannot be reissued. I didn't know this existed. So it's a forfeited share. S corporation, a corporation that has been elected to be taxed under the subchapter S of the tax code. S corporation status means that a corporation can pass its income and losses onto its shareholders. All corporations start off as C corporations and then must make an election with the IRS in order to become an S corporation. S corporations can revoke their S corporation election in order to become a C corporation again, but should consult attorneys and accountants before doing so. S corporations cannot have more than 100 stockholders. Stockholders who are not individuals, stockholders who are non-resident aliens, or more than one class of stock. Consequently, startups are almost never S corporations. I have heard of S corporations. It sounds like it's something that would help a small business that's owned only by individuals. I don't know if it's good for investment because then a firm cannot own the equity. You might still be able to enter an agreement with a financial instrument, like you might still be able to enter a convertible note, but for that note to convert, you would have to convert into a C corporation. So I'm not sure. I've never done it. Safe harbor. We already went over this, but it's the space created by clear boundaries in laws and regulations designed to provide people with certainty about how to comply with a given law or regulation. So basically, if you're given safe harbor, that means you're going to be safe from the law in one regard or another. If you do that 409A valuation, which we went over, if you get a qualified, what do they call it, appraiser, somebody to value your startup, then you're going to be in a safe harbor from the IRS coming after you for having too low of a valuation, unless they did a really bad job, the appraiser, or you lied to the appraiser. Secretary, a common officer position in corporations. The secretary is generally responsible for maintaining the corporation's records. Some states have laws that require or give special status to the secretary's signature on certain documents. Security, generally this term includes anything a startup might issue to people in order to raise money or share profits. This includes stock options, convertible notes, safes, etc. Series A, B, C, etc. Preferred stock financing. The name typically given to the first, second, third, etc. equity financing of a startup. Okay. Share, what a stock is divided into. What stock is divided into? Stock is divided into shares? Okay. I thought stock and share were the same. What stock is divided into? A stock is divided into shares? Well, I wish they wrote more on that one. Shares available for issuance. The number of shares the corporation can issue. This is the number of authorized shares minus any shares that have been issued or otherwise reserved, plus any shares that have been repurchased and not retired. Yep. So, yeah, it's the number of authorized shares. I don't know why they, minus any shares that have been issued or otherwise reserved. So, we have 1 million shares that we can issue. We haven't done anything else yet. Startup. For the purposes of this handbook, companies that plan to raise or have raised money from an accelerator or a VC. Stock, see a page, sure. Stock class. The stock of a corporation can be organized into classes. We already went over this. Stock option, the type of security that allows people to purchase common stock at a fixed price in the future. This is what you give to employees. Stock series. Stock classes can be further divided into series. Vesting, we already went over. Warrant, a type of security that allows people to purchase common stock at a fixed price in the future. They largely function like stock options and differ primarily in that they are typically issued to investors and partners. So I guess a warrant is probably different than an option because options have certain rules governing them to help employees, and I'm guessing the warrants do not have those rules. Public benefit corporations. Delaware public benefit corporations, also known as PBCs, are an increasingly popular method that founders use to embed their principles into the DNA of their business. Delaware law enables founders of PBCs to adopt corporate governance principles that let them run their businesses as responsible and sustainable organizations. Delaware PBCs are managed for the benefit of all of their stakeholders, including workers, customers, and the community, not just stockholders. A Delaware PBC is governed by the same rules as a traditional corporation, with a few simple alterations. Most importantly, the board of directors must balance the financial interests of its stockholders together with one or more public benefits, as well as the interests of anyone materially affected by the corporation's conduct. This is in contrast to a traditional Delaware corporation, which is required to maximize stockholder value regardless of the outcome for other stakeholders. Delaware PBCs must also issue a report on their sustainability performance to stockholders once every 2 years. So I think what this is about is a lot of people say, like, okay, the corporation is always, or it's not that they say, officers, like I'm an officer of a corporation, we're accountable to our stockholders to do what we can to maximize the value of the company for shareholders. And that's a bad thing and a good thing, right? It means that I can't act in my own self-interest. So I can't give myself a ridiculous salary because that's not in the shareholders' interest, right? Or I can't give myself a bunch of shares to inflate, to get myself money because it's not in the shareholders' interest. So you can sue on the grounds that this officer has violated their fiduciary duty. So I'm guessing these public benefit corporations get more leeway. They can now do unprofitable things because they are a PBC. And I'm guessing that's what this is about. I don't know. I haven't done a public benefit corporation. Why choose a public benefit corporation? One reason that founders choose to form their startups as Delaware PBCs is for increased flexibility. For example, actions that maximize stockholder value might have severe negative side effects on workers or customers. A Delaware PBC would be allowed to take negative effects on workers and customers into account in deciding what to do, whereas a traditional corporation cannot take those interests into account unless they contributed to stockholder value. Startups also elect to become Delaware PBCs in order to attract customers, employees, investors who want to be affiliated with an organization that has a purpose beyond profit. The willingness to meet Delaware PBC requirements signals commitment to the specified public benefit and broader public. There's a note here, no tax effect. Some people think that Delaware PBCs are taxed differently than regular corporations. However, being a PBC does not impact a corporation's federal tax status. Like any Delaware corporation, a Delaware PBC is a C corporation by default. B Corporation certification. A B Corporation certification is different from being a PBC, although the two are often confused. A B Corp is a for-profit corporation certified to meet rigorous standards of social and environmental performance, accountability, and transparency. The certification is administered by the B Lab, a nonprofit organization. For Delaware corporations, the B Corp certification process requires PBC status. Thus, many Delaware PBCs are B Corp certified, but many more are not. A Delaware PBC is eligible to be certified by the B Lab as a pending B Corp for the first year of its existence. Each pending B Corp is given 1 year by B Lab to certify as a B Corp, after which it loses its pending B Corp status. There is no requirement that a Delaware PBC become pending or certified B Corp. So to be honest, I didn't really understand that last this paragraph here. I'm sure if you were forming a public benefit corporation, it would make a lot of sense. But anyway, that is it for the Clerky Guide. I don't know if I need to do a YouTube sign off. I'll probably just end it abruptly.